we're doing is giving the power back to the people so that you can decide how you want your affairs to go, as opposed to letting the probate court decide who's going to be in charge of your finances, who's going to be in charge of your healthcare decisions in the event that you're unable to do so. So, if you want to make sure that your wishes are carried out, then it's very important that you get a plan in place and identify the trusted family advisors, being your healthcare and financial power of attorneys. Now, something that often comes up is, well, I only have one child, and why do I need a power of attorney? Well, you need a power of attorney because you want to give your child the ability to take care of the affairs in the event that you are unable to. So what do I mean by that? A couple years ago, we were working with a guy who had no children, no wife, but he had siblings, and he had a stroke, and he was in the hospital and kind of in a vegetative state where he couldn't make any decisions, and his two sisters disagreed on how the decision making was going to happen. But he had designated one of his sisters to be his healthcare and financial power of attorney. Now, the only thing that he did that created a little friction was it was a springing power of attorney, which meant it did not go into effect until two doctors said that he was unable to make these decisions for himself. By doing so, they had to supply documentation from the hospital and two doctors to his bank. And what ended up happening is they were unable to get the language right that was sufficient for the bank to allow the power of attorney to actually act. And the reason why I say that is because when somebody is in a situation where they need their agents to be able to act, you want them to be able to act in a situation where there is no friction. And in this gentleman's situation, there was friction. His sister could not act because the language did not meet the bank's requirement. And so I bring that up because if you are the sole heir and you want to take care of your family, right, member, but you don't have that legal authority, third parties may reject your ability to act, even though you are the sole heir, even though there's nobody there to contest it. The third parties may not recognize it. So the better avenue is to go ahead and get your affairs in order. Make sure that you have the proper legal authority to act. Now, another misconception that we see is people thinking that probate isn't going to cost that much. So let me tell you, according to the Ohio Revised Code, there is a statutory fiduciary fee as follows. It's 4% for the first 100,000 and 3% for everything over 100,000 but less than 400,000, and then 2% for everything over 400,000. So if you have an estate that is worth $250,000, you're looking at 4,000 for the first 100,000 and then 4,500 for the 150,000. So an $8,500 fiduciary fee. Now, in addition to that fiduciary fee, the attorney's fee can be the exact same amount.